I feel that the court is calling for mutual tolerance, respect, and understanding of each other's right to exist, a call that I think is sadly needed today, a time of seemingly great turmoil and divisiveness between people who are supposed to be standing united as the several states of a greater union, and, in my personal opinion, as citizens of a world that must coexist for many years to come. Hello everyone, thank you for coming. I'm Leonard French, your favorite copyright attorney. On Monday, the United States Supreme Court ruled in Masterpiece Cakeshop versus Colorado Civil Rights Commission, a much-anticipated opinion that was supposed to give the several states guidance on how the court handles the intersection of religious liberty and unlawful discrimination. The opinion and its reasoning turned out a bit different than many anticipated, though there was growing agreement in the legal community that the court would have difficulty and might kick the can down the road for another time. But while many are saying that kicking the can is exactly what happened, and it's true that the opinion has little precedential weight, it is still an important opinion from which we can learn many lessons regarding the way a future court might handle this kind of issue, and therefore the way society is more or less expected to govern itself. Now, I would like to review every word of the opinion with you, but fortunately or unfortunately, the opinion, the concurrences, and the dissents total almost 19,000 words. Instead of nearly 3 hours of review, let's try and sum this up in less than 20 minutes. The very basics are that Colorado, like many states and the federal government, prohibits discrimination against people based on certain immutable traits like gender, race, or sexual orientation. Colorado, as a state in the Union, is also subject to the U.S. Constitution's First Amendment, which prohibits the government from placing unnecessary restrictions on religious beliefs. The situation in this case occurred in 2012 when a couple, Charlie Craig and Dave Mullins, who identify as homosexual, requested a wedding cake from Masterpiece Cakeshop proprietor Jack Phillips. Phillips informed the couple that he does not create wedding cakes for same-sex weddings. He explained, "I'll make your birthday cakes, shower cakes, sell you cookies and brownies, I just don't make cakes for same-sex weddings." The couple left the shop without further discussion. Craig's mother followed up the next day. Phillips further explained his religious opposition to same-sex marriage. Now this is important. While the court takes very seriously the fact of Phillips' sincerely held religious beliefs, they must also balance Colorado's Anti-Discrimination Act, known as the CADA. This act prohibits discrimination on the basis of sexual orientation as well as other characteristics. The state and its governmental entities have the authority to protect the rights and dignity of gay persons who are, or wish to be, married, but who face discrimination when they seek goods or services, says the court. That prohibition applies to any place of public accommodation, which broadly includes any place of business engaged in any sales to the public and any place offering services to the public, but excludes a church, synagogue, mosque, or other place that is principally used for religious purposes. In Colorado, discrimination complaints are initially handled by the Colorado Civil Rights Division, who investigates the veracity of each claim and then turns over meritorious claims to the Colorado Civil Rights Commission. The division found Craig and Mullins' claims meritorious and turned them over to the commission. It said that Phillips had declined to sell custom wedding cakes to about 6 other same-sex couples on the basis of their orientation. The commission sent the case to an administrative judge for a formal hearing. Now, remember that people also have the right to exercise fundamental freedoms under the First Amendment as applied to the states through the 14th Amendment. According to the court, the freedoms asserted by Phillips are both the freedom of speech and the free exercise of religion. This is very important. The court takes very seriously the sincerity of Jack Phillips' religious beliefs. They explain that he has been a devout Christian his whole life. His main goal in life is to be obedient to Christ, and that he seeks to honor God through his work. Phillips raised 2 constitutional claims before the judge. He first asserted that applying kata in a way that would require him to create a cake for a same-sex wedding would violate his First Amendment right to free speech by compelling him to exercise his artistic talents to express a message with which he disagreed. He also contended that requiring him to create cakes for same-sex weddings would violate his right to the free exercise of religion. The judge ruled against Phillips and the Cakeshop and in favor of Craig and Mullins on both constitutional claims. The judge said that preparing a wedding cake is not a form of protected speech, and that creating Craig and Mullins' cake would not force Phillips to adhere to an ideological point of view. The judge also found Colorado's anti-discrimination law to be a non-discriminatory law of general application. The commission agreed and ordered Phillips to make cakes for same-sex couples like he would for heterosexual couples, along with staff training, changes to company policies, and 2 years of compliance reports. Phillips appealed. The appeals court rejected Phillips' arguments. The Colorado Supreme Court declined to hear the case. Writing for the United States Supreme Court, Justice Kennedy writes, "Our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. For that reason, the laws and the Constitution can, and in some instances must, protect them in the exercise of their civil rights. At the same time, the religious and philosophical objections to gay marriage are protected views, and in some instances protected forms of expression. As this court observed in Obergefell v. Hodges in 2015, the First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths. Nevertheless, while those religious and philosophical objections are protected, it is a general rule that such objections do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law. When it comes to weddings, it can be assumed that a member of the clergy who objects to gay marriage on moral and religious grounds could not be compelled to perform the ceremony without denial of his or her right to the free exercise of religion. This refusal would be well understood in our constitutional order as an exercise of religion, an exercise that gay persons could recognize and accept without serious diminishment to their own dignity and worth. Yet if that exception were not confined, then a long list of persons who provide goods and services for marriages and weddings might refuse to do so for gay persons, thus resulting in a community-wide stigma inconsistent with the history and dynamics of civil rights laws that ensure equal access to goods, services, and public accommodations. Petitioners, Jack Phillips here, conceded, moreover, that if a baker refused to sell any goods or any cakes for gay weddings, that would be a different matter, and the state would have a strong case under this court's precedents that this would be a denial of goods and services that went beyond any protected rights of a baker who offers goods and services to the general public and is subject to a neutrally applied and generally applicable public accommodations law. The baker likely found it difficult to find a line where the customer's rights to goods and services became a demand for him to exercise the right of his own personal expression for their message, a message he could not express in a way consistent with his religious beliefs. The court found that storekeepers did have a right under Colorado law to decline to create specific messages the storekeeper considered offensive. Indeed, on at least 3 occasions, the commission concluded that a baker acted lawfully in declining to create cakes with decorations that demeaned gay persons or gay marriages. But, unfortunately for us, we never get to the meritorious consideration of the rights of the couple and the rights of the shopkeeper. On May 30th, 2014, the 7-member Colorado Civil Rights Commission had convened publicly to consider Phillips' case. At several points during its meeting, commissioners endorsed the view that religious beliefs cannot legitimately be carried into the public sphere or commercial domain, implying that religious beliefs and persons are less than fully welcome in Colorado's business community. One commissioner suggested that Phillips can believe what he wants to believe, but cannot act on his religious beliefs if he decides to do business in the state. On July 25, 2014, the commission met again. This meeting, too, was concluded in public and on the record. On this occasion, another commissioner made specific reference to the previous meeting's discussion, but said far more to disparage Phillips' beliefs. The commissioner stated, "I would also like to reiterate what we said in the hearing or the last meeting. Freedom of religion and religion has been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust, whether it be, we can list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it is one of the most despicable pieces of rhetoric that people can use to use their religion to hurt others." The court continues, "To describe a man's faith as one of the most despicable pieces of rhetoric that a person can use is to disparage his religion in at least two distinct ways, by describing it as despicable and also by characterizing it as merely rhetorical, something insubstantial or even sincere." The commissioner even went so far as to compare Phillips' invocation of his sincerely held religious beliefs to defenses of slavery and the Holocaust. This sentiment is inappropriate for a commission charged with the solemn responsibility of fair and neutral enforcement of Colorado's anti-discrimination law, a law that protects discrimination on the basis of religion as well as sexual orientation. The court noted that no objections or correction to these comments came at any time. They found that just as no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, it is not, as the court has repeatedly held, the role of the state or its officials to prescribe what can be considered offensive. The Colorado court's attempt to account for the difference in treatment elevates one view of what is offensive over another, and itself sends a signal of official disapproval of Phillips' religious beliefs. For the reasons just described, the Commission's treatment of Phillips' case violated the state's duty under the First Amendment not to base laws or regulations on hostility to a religion or religious viewpoint. That hostility was inconsistent with the First Amendment's guarantee that our laws be applied in a manner that is neutral toward religion. Phillips was entitled to a neutral decision-maker who would give full and fair consideration to his religious objection as he sought to assert it in all of the circumstances in which this case was presented, considered, and decided. And then the court says what I believe is the most important line in this entire case. These disputes must be resolved with tolerance, without undue disrespect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market. The outcome of cases like this in other circumstances must await further elaboration in the courts. The court reverses the decision of the Colorado Court of Appeals, and therefore the Colorado Civil Rights Commission, eliminating the discrimination charges against Jack Phillips. And that's it. We don't get a ruling on exactly what the tolerance and requisite balancing of sincere religious beliefs and anti-discrimination laws is. We will have to wait until other issues arise and make it through the court system before we can potentially receive another ruling. And who knows how long that might be. It's not like people were waiting on this ruling to put their "No Gays Allowed" signs back up in their store windows, something that took exactly 2 days at Amex Hardware and Roofing Supplies in Tennessee. Link in the description. After about 2 days of backlash, the hardware store changed its message to, "We reserve the right to refuse service to anyone who would violate our rights of freedom of speech and freedom of religion." To me, this ruling, while not precedential in the traditional sense, does offer persuasive guidance that future courts should incorporate into their interpretations of anti-discrimination laws, free speech, and religious liberty. This ruling seems to call for tolerance in the legal sense. Citizens need to be allowed to exist in an economy without facing discrimination at every turn, and citizens also need to be allowed to practice their sincerely held religious beliefs without also facing unlawful discrimination. Thus, the court seems to affirm that both rights are equally valid. That means the "No Gays Allowed" sign would be considered intolerant and an illegal way to express one's sincerely held religious beliefs. The hardware store owner would only be allowed to discriminate against homosexuals so long as his discrimination is based on a sincerely held religious belief that would also stand up to governmental scrutiny if tested by a court. Insincerely held religious beliefs in name only would not withstand scrutiny and could qualify as illegal discrimination. And even a sincerely held religious belief may not overcome anti-discrimination laws if there isn't an element of free speech or expression in the selling of the goods or providing of the services. Thus, the hardware store may not be allowed to deny service to gay people simply because there is no element of speech or expression in the selling of tools and home hardware. But, likewise, equal rights does not mean equal rights extinguish individual religious liberty. Society must find a balance between requiring business owners to suspend their sincerely held religious beliefs while also upholding the right of citizens to not be subject to daily indignities in the marketplace. So, I feel that the court is calling for mutual tolerance, respect, and understanding of each other's right to exist, a call that I think is sadly needed today, a time of seemingly great turmoil and divisiveness between people who are supposed to be standing united as the several states of a greater union, and, in my personal opinion, as citizens of a world that must coexist for many years to come. In summary, gay people shouldn't have to suffer indignities on a daily basis while participating in an open market, and citizens need to be tolerant or not unduly disrespectful of each other's sincerely held religious beliefs. It's possible for sincerely held religious beliefs to override anti-discrimination laws when the good or service offered is created by the storekeeper's speech or expression, but those religious beliefs do not override when the storekeeper's speech or expression is not part of the good or service. None of this is black-letter law or precedent. Instead, this is all guidance to be cited further down the road if and when the next genuine case or controversy presents itself. Obviously, I've skipped a lot of the court's history and reasoning, as well as 2 concurring opinions and 2 dissenting opinions. If you'd like to read those, I have them up on lawfulmasses.com. And your favorite patent attorney, Kurt Mueller, also has made a video for Lawful Masses, which I'm posting simultaneously with this one. Please check out his video for another perspective on this remarkable case. This video and the Lawful Masses community are made possible by your support. Please visit patreon.com/ljfrench for more information on becoming a monthly supporter yourself. June's Patreon supporters are, at the $500 level, Kareem Harper. This is Kareem's 3rd month of support at this level. At this point, I'm calling you our benefactor, Kareem. Thank you very much for your support. At the $50 level, Jonathan Doe, DJ Gilcrease, John Steele, Gavin Barnard, Evie, Andy, Kyle Mudrock, Sean McNamara, Vera Montaigne, John H. Anderson, Michael Pierce, and William Gonzalez. Thank you all very much for your support. DJ, your Lexmark video is being shot and will be out this week, I promise. And the 215 $5 plus supporters are scrolling on the LED panel behind me and on the screen. Thank you all so much for all of your support. I look forward to the discussion in the comments and on the community Discord channel, link in the description. And I'll see you all for our live show on Sundays at 10 a.m. Eastern on twitch.tv/Leonard French. I hope you enjoyed this video. Thank you for joining me, Leonard French, your favorite copyright attorney, as we try to educate the lawful masses. Have a good one.